Hello, I'm David DeLugas, the $99 lawyer. It's a few days after the date each week that I wanted to post the Q&A, but I was a bit under the weather and unable to take care of that task. So that raises the question, what do you do if you're involved in a lawsuit and you take ill, or you have some other event that prevents you from getting to court on time, or prevents you from getting some task done for which there is a deadline? Well, first, let me suggest this. If you're involved in a lawsuit, whether you're the plaintiff and you started this legal action, or you're one of the defendants and you were sued or your company was sued, make sure that you have in your smartphone or your tablet or on a piece of paper that you carry with you or have with all your other legal papers, the name, telephone number, and address of the judge, the staff attorney for the judge's secretary or assistant, and also perhaps what they might call the case manager or the calendar clerk. In addition, please have the phone number available for the court clerk where your action is pending. In addition, have the name, telephone number, and address of opposing counsel or the opposing party if not represented. If they're represented, the person you need to have is the name of the attorney, email address, phone number, and mailing address. Now, why would you want all of those on the device that you have in your hand available to you? Well, because if you're in the car on your way to the courthouse and you're supposed to be there for a calendar call at 9 a.m., and there is a massive traffic wreck in front of you and you can't get there on time, you better call the clerk. You better call the judge's office. Indicate that you're en route, that an unforeseen accident occurred. You're going to be there at a certain time, and make sure that you keep a record of that call, and your device will allow you to show that you called the clerk's office, the judge's office, and inform them. I recommend the judge's office, of course. Now, it brings up the idea of, well, what happens if you're late? First of all, try to be early. If you're not an attorney, you may or may not get cut very much slack or be forgiven. And there are rules of court and case law in many jurisdictions that does not require the trial court to forgive you for being late. I've been in court many a time when some person representing themselves did not appear on time, and the judge struck their answer and entered a default judgment against that person. And that's the end of it. And I've seen that person walk into the courtroom 15, 20 minutes later, and the judge say, sorry, you're late. And that's the end of it. Now, it can be unraveled, but again, it's going to be a difficult process, time-consuming. It's not certain that you will be able to unravel this mess, so better never to get in it. So, again, to recap, if you're going to be late, make sure you let the court know, and that means the particular judge where you're supposed to be. Secondly, call opposing counsel and inform them that you're en route and you're on your way. There is, and while this may cause a few of you to chuckle, professionalism suggests that an attorney who's been informed that the opposing party is running late, but they're still coming, has a duty to inform the judge of this communication, and in many instances will be somewhat compelled to be accommodating and allow for the late arrival. Now, if you're sick and you simply cannot be there, it's not going to be enough to call and say, I'm sick, I'm ill, I have a note from my doctor. You will need an affidavit. Now, that may simply be the doctor's statement that you're too ill to travel, you're too ill to appear, you're too ill to be able to handle matters, especially those that require good thinking on your feet and being prepared, and have that notarized and get that by fax or scan it and email it or have it delivered to the court to indicate that you have a legitimate reason. Now, understand, many times judges hear that parties are ill and they can't be there. And it's not up to the judge to decide how ill you are. It's up to a doctor to make that decision. But if the judge doesn't have something under oath from a doctor, should the judge just believe the note from the doctor, the so-called doctor? Because think about it. Somebody who just wants a continuance that they can't otherwise get just has a friend, maybe they even have a friend who's a legitimate doctor who's willing to go out on the limb a little bit and write a note that says you're sick. Okay. Well, judges have had enough of that over the years, and by and large, the requirement is that you have a statement under oath from a doctor indicating that you're too ill to appear in court, and that's your excuse. If you have a desire for a continuance or something else, better file that request early on and have legitimate reasons. And the fact that you have a wedding of a friend coming up or you have other business out of town, these are not going to be considered legitimate legal excuses. So please, please do not count on the court to grant your continuance. It is possible that the court will, but please don't count on it. And of course, depending on your relationship with opposing counsel, you can always get their approval. But again, even if the opposing counsel indicates that they have no objection and they will agree to a continuance, the judge still may not grant that continuance request that you're making, because it's up to the judge to decide how to handle his or her calendar. So don't count on that either. So if you take nothing away from this particular question and answer, it's what do you do if you're ill? What do you do if you're running late? First, communicate with the court directly. Communicate early. Better to do it in writing. Phone call is also good, but I would follow up a phone call, if you're not going to show at all, with something in writing, including that affidavit. And as always, it's just better to be there and be on time. Even if you show up and you have the flu, a high fever, and everything else, have the judge send you home because you're obviously sick, rather than not show and put at risk your entire case, that you either will have your case thrown out for quote-unquote failure to prosecute it, to pursue that claim that you made, or to have your answer stricken and a default judgment entered against you because you failed to appear to defend. All right. Now, if you have any questions or you'd like to discuss this or any other matter associated with a claim that you think you have, or you're concerned about a claim somebody is pursuing against you or you think they have against you, consider booking a session with me, the $99 lawyer. I'd be happy to help. Thanks so much.